the state or corporate actors are using the law. But I think in some instances, it's quite opportunistic, right? There's a use of the law and abuse of judicial process or exclusive monopoly on kind of the violence of prosecution and police forces and military to punish those who would dare to confront, power and demand justice. But we're also then seeing when those institutions are successfully mobilized, when courts and the law is successfully used by advocates to rebalance power, to call into question status quo conduct, then we're seeing a kind of flip, a bait and switch, and flip on the institutions and law itself.
Hello and welcome to Planet Critical, the podcast for a world in crisis. My name is Rachel Donald. I'm a climate corruption journalist and your host. Every week I interview experts who are battling to save our planet. My guests are scientists, politicians, academics, journalists, and activists. They explain the complexities of the energy, economic, political, and cultural crises we face today, revealing what's really going on and what they think needs to be done. These are the stories of the big picture. Go to planetcritical.com to learn more and subscribe. My guest this week is Nikki Reisch. Nikki is the director of the Climate and Energy Program at the Center for International Environmental Law, which uses the law to ensure a just and sustainable society. Nikki joins me today to discuss some of the major climate litigation milestones that have been taken in the past year, including the Swiss grandmothers, which took their nation to court, leading to the European Court of Human Rights deciding that the climate crisis is a human rights issue. Nikki also walks us through the different advisory opinions of international tribunals which are happening around climate, and explains how some states are walking away from treaties that are no longer fit for purpose, reminding us that the law can update with the times. Throughout the episode, we also have some nuanced discussions about whether or not the law is fit for purpose, the difficulty of updating the law to the times, and even the fact that we live in an era where the rule of law is being undermined on national levels and on the international level. It is at this point that Nikki reminds us that consent is the basis for international law. That, and I quote, "custom and practice ripen into law," before mentioning the network of movement and activism that law exists within, so that we citizens may capture the decisions made in courtrooms and run with them on the ground to enact real change. Just as activists who are wielding the power of the law against the fossil fuel industry and even against their own states are doing as we speak with great success around the world. I hope you all enjoy the episode. If you do, please share it far and wide. And if you're loving the show, become a patron on Patreon or support Planet Critical with a paid subscription at planetcritical.com. By signing up, you'll get the Planet Critical newsletter inspired by each episode delivered straight to your inbox every week. You'll also have access to the wonderful Planet Critical community who are full of inspiring thoughts, ideas, critiques, and determination. The links are in the description box below. I'm so grateful to everyone who chooses to support the project. I'm a vehement believer in ad-free and open access content, so Planet Critical wouldn't exist without the direct support of the amazing community. Thank you so much to all of you who believe in Planet Critical and keep the project going every week. Nikki, thank you so much for joining me on Planet Critical. It's a pleasure to have you on the show.
Thanks so much for having me.
My first question for you is, why is the world in crisis?
That's a tremendous question in scope and importance. I think at this time when the world is facing such a heightened level of urgency and convergent crises, there are so many different types of crises that are affecting humanity and the planet and that converge. But I think one of the common roots of the ecological polycrises, the planetary crises that we're facing, is fossil fuels. And I think that when we look at climate change, at plastics pollution, and at biodiversity loss, those three planetary crises that are among the challenges that we are facing, we see fossil fuels as a common source contributing to all of them. Not only do fossil fuel production and combustion contribute the greenhouse gases that are warming the planet, but they are the source of plastics and plastics pollution and agrochemicals and petrochemicals that are the precursors to those plastics and other products that are poisoning the planet and people on it and other forms of life. But they're also driving biodiversity loss. So you can see that common crisis. But I think it's not enough just to point to the physical material that's underlying those crises, that it's really systems that have been designed around and that put on a pedestal accumulation without limit. I think it's hard to get away from the fact that the crises that we are facing are really around this focus on and almost lionization of more, of growth in excess, of capitalist accumulation, really. And that putting the possibility of and putting as the pinnacle of achievement just excessive and obscene levels of accumulation have triggered and continue to trigger crises of multiple types, including structural violence. And we see that system that puts growth above all else, of not sufficiency or well-being, but more, and in consumption patterns, in production patterns, in ways of measuring and vaunting what is valuable. I think that not only produces inequality, but is reproduced by that inequality and feeds into a vicious cycle that we see really underpinning so many of the types of structural and environmental violence, of marginalization that are tearing the planet apart. And I think that kind of excessive accumulation and unequal access to and control of resources manifests in corporate control and capture of so many different systems, and including, I think, one of the aspects of the crises we're facing now that is taken on outsized importance is the manipulation and control of information, and the role that disinformation is playing in distorting our ability to understand the root causes and to tackle them. So it's a long answer, I think, to what is obviously a complex and provocative question to launch into conversation, because there are so many different dimensions of the crisis. But what I think is so powerful is that so many of them interlink and really point to these common roots in exploitation and extraction for the purpose of limitless accumulation, really, and how systems and structures, including laws, have been designed to respond to, enable, and perpetuate that.
What a brilliant answer. Thank you so much. And given that bit that you just said at the end, that some laws have been designed to further perpetuate that limitless extraction and exploitation, I'd like to go straight in with a philosophical question, really, which is, using the adage of Audre Lorde, can you tear down the master's house with the master's tools? Given the common law essentially was established to protect private property and to protect the interests of the elites, what are the limitations of law when it comes to effectively tearing down the source of both political power and physical power, material power, which is fossil fuels? Can it really do that very thing when it was designed to do something very different at the beginning?
Well, I think it's important to recognize that the law is not static, right? So that the law is a social construction, and that it is constantly changing. And so one of the things that the organization I work for, the Center for International Environmental Law, and many of the networks and movements we work with strive to do and have done is to influence the evolution of the law, not only interpretation of existing law, but actually pushing the bounds and frontiers of law and establishing new principles and codifying those principles and norms in law. And we've seen, law change over time. Of course, we've seen the emergence in the post-World War II era of the modern human rights regime, which of course has underpinnings in and its roots in long-standing fundamental principles. But I think there are obviously limits to the law. I'm not a devotee of law in the sense that I think it is a silver bullet or a single solution. I think it is one tool among others. But I think it is very important to think about ways to turn laws that have been utilized to reinforce power and control to turn them around and maybe creatively think about the ways that applying them in a new and very rapidly changing factual context can bring about different results, right? And so we've seen that, what might have been permissible conduct at some point in the past becomes impermissible and unacceptable in the context of changing circumstances. So in order to take on climate change or fossil fuel production and use as not just morally or politically unacceptable, but legally impermissible, right? We need to think about how the idea at the heart of common law, tort duties, right? Duties of care, of taking reasonable care to not create harm and danger to others, what that standard of reasonableness is, what is the requisite level of caution and care will change over time. And so I do think what we are seeing is creative use of longstanding law and legal principles to refocus on conduct that today, in light of uncontested or uncontestable, although often contested science, is really no longer acceptable, even under the rules that powerful actors have helped to create and manipulate so much. But there's obviously more to unpack there. I mean, I think the ways that law is being used are manifold, right? I mean, there isn't just one off-the-shelf climate case. There are many different types of law or legal regimes that are being brought to bear to push states and corporations not only to do more to overcome the decades of inaction and failure to act, but also to prevent them from continuing to contribute to the problem, the primary driver of climate change, fossil fuel production and use in particular. So yeah, I mean, I'm eager to get into and happy to talk about what are some of those, what are some of those strategies that we've seen make headway, and where do we think they're kind of cracks in the edifice that is, has helped to reify the status quo of extraction and extractivist economies.
Please go for it. What are some of these climate litigation cases? Feel free.
Well, I mean, it's always hard to find the precise way in because there are so many different cases, and we've seen over the last decade or two really kind of this rapid snowballing and a rising tide. I think that it's often said, as temperatures and sea levels rise, so too do demands for climate justice and climate action. And I think it's no wonder that we're seeing more and more people turn to courts and try to appeal to the law, because as with other social crises, economic, environmental crises and injustice, when harm mounts, and it clearly is, we're seeing ever more evident impacts and devastation caused by climate change. People are turning to courts to seek justice because you have those impacts mounting, and at the same time, action to address the known causes and foreseeable and indeed unfolding consequences is lagging behind. And so in that gap, there's a recourse to courts and the law to provide some remedy and justice. So that's kind of the why behind it, I think, is no surprise. And that's why we're seeing, an ever increasing diversity of plaintiffs turning to courts, in different jurisdictions, different combinations of individuals and communities, of organizations, even of cities, municipalities, and states turning to courts. But we're also seeing recourse to a wider variety of bodies of law, from constitutional and human rights law to tort law to corporate law. That there are, climate change affects so many different aspects of society and the economy that it has implications for the way that we understand so many of those of how those laws apply and should be enforced. So maybe it's useful as a way in to just talk about the historic moment that we're in right now, not only with so many cases pending still around the world, but some really landmark decisions that have been handed down just in the past year that I think are key markers of progress in how the idea of issue of climate change and its causes and impacts have been brought to the world of courts and judicial remedy, and what role that's playing in animating and breathing life into the movement for justice more broadly. So earlier this year in April, we saw the European Court of Human Rights hand down its first decision in the climate cases that had been brought before it. And we saw a landmark decision in the Klimassenioren case, which is the case often called the Swiss grandmother's case, right? Of these elder Swiss women who took on the Swiss government's inaction. And what we saw from the European Court was a very clear recognition that the climate crisis is a human rights crisis. So for the first time, we had this international court acknowledging, number one, that reality of the severity and the impacts of climate change, that it was having real and concrete, demonstrable impacts on people's lives and their ability to exercise and enjoy their rights. And critically, the court held that failing to do enough on climate change, the government's failure to take adequate science-aligned action that was sufficiently ambitious and rapid to actually mitigate the risk of and these impacts of climate change, violated its human rights obligations, violated the rights of people and its own obligations. And that sending that signal to, a powerful economy. Switzerland may be a relatively small country, but it is a significant economy in the world. And to say, no, it's not just a moral and political issue. This is not just a rhetorical point. You have long-standing legal obligations under human rights law to do more to address this crisis. And you will face legal consequences if you don't. And that, I think, was a crucial moment, and really hats off to the organizations that supported the courageous women to take this issue up and on and really mobilized around it and used this moment to galvanize attention and understanding and to motivate people to take on and demand justice and action from states. But it also reinforced that courts have a critical role to play, that the issue of climate change is not beyond the reach of the judiciary, is not something that doesn't belong in the courtroom, but in fact that courts have a critical role to play in enforcing legal obligations to protect against and prevent foreseeable harm to human rights. And that's been a longstanding obligation that exists and is the reason why states need to do more to regulate. Private and corporate actors need to take action on countless environmental threats and other foreseeable threats to human rights. And climate change is no different. And it means that there is a need to just bring those longstanding duties to bear in the midst of this escalating crisis. And that decision not only is important for Switzerland, which of course is the country that was bound by it directly, right? But it has implications for all of the member states of the Council of Europe who are bound by the same European Convention on Human Rights. And therefore, the signal to them was also clear that if you don't close the gap between your climate policy and what the science shows is clearly necessary to prevent further devastation and harm and suffering to people and their rights, then you too may face legal consequences. And that signal continues to reverberate. So that's just one, but maybe pause there.
Yeah. I'm curious as to what some of these legal consequences could be, and whether or not we now live in a world where they could be taken slightly less seriously. Now, excuse me, I'm going to go off the philosophical deep end again here. But I'm thinking about the case that was successful in Holland against Shell, in which Shell was essentially proven to, not be taking enough action, and they have until 2030 to get into climate shape, essentially, and to meet action, or otherwise there will be legal and financial consequences. And they have recently announced that they are, like every other private fossil fuel company, stripping back the climate goals and going for more extraction and more production. And so it makes one think that they are not taking the results of that case very seriously. And also, I do feel like it's important to frame these discussions of international law within the reality that we have today, which is that there is a country that is breaking international law every day and supported by the greatest powers in the world to do so at the cost of tens of thousands of lives. And certainly, I remember in the first few months of the catastrophe and violence unfolding in Gaza, people, commentators saying, this is the unfolding of international law. This is completely destroying the strength of international law. So I'm going to pause there, but within that framing, what are the legal consequences and how do we ensure that they are taken seriously?
Well, I'm not going to pretend that it's an easy question. And I very much agree that we are living in a moment of this flagrant flouting of international law and norms and blatant, abhorrent violence and devastatingly inhumane atrocities. And I think that, that obviously has raised a lot of questions about whether international law and international institutions are fit for purpose, right, and have the power. I think it's really critical for those of us who believe in the importance of and the principles underlying international law and the importance of international cooperation and accountability, not to abandon the institutions that have been mandated, like the International Court of Justice, to set down markers, to memorialize transgressions, and to reinforce what the law is. You know, the fact that an institution doesn't have a big stick it can wield to compel compliance doesn't mean that it has no force and value, right? That the compliance and the enforcement has to come from people and institutions, communities, and the states then aligning their action with those legal norms and principles that have been reinforced. And I think it's critical for us at minimum to bear witness as to these transgressions. Like, I guess one question is, you know, what is the power of law, right? But what is power without law, right? It would be, it's tyranny. So we need to reassert and reinforce that there are agreed and existing norms and that this conduct, among others, is on the wrong side of them and is clearly not the acceptable or accepted. And that then, of course, there are lots of appeals being made in the context of the violence and violations in Gaza to utilize other measures, diplomatic tools, other protest and reputational harm, economic measures, et cetera, to induce Israel to change its conduct and to cease these violations. But I think that the power of those, you know, courageous entities, voices, people, and even states who have brought these issues before international courts and who continue to decry and seek accountability for these violations can't be overstated. I mean, I think that it remains a critical function of law and accountability efforts is to reinforce the collective understanding of right and wrong, and to at least lay the foundations for and put tools at the disposal of those who would use them and bring those to bear in various local and national and regional contexts. You know, there is no government on high, world government, that's going to sit down and control the conduct of public and private actors. But I do think it is a critical moment to reinvest in the moral forces that we see coming to the fore in those multilateral spaces, and to reinvest in the promise of them, not appealing to the dominant powers that have controlled and stifled progress in multilateral spaces for so long. But, you know, looking to the leadership of the global South and emerging economies who have, it's no surprise, it's South Africa that took this case, but it's also the Pacific Island states in the context of climate change and others who have been consistently on the forefront of the climate justice movement, right? And who have not only maintained their lines in the face of existential crises that they're on the front lines of, but, they're on the front lines of those impacts and they're on the forefront of the movement for justice. And I think that, what I was saying before about this historical moment that we're living in now is also marked by these 3 ongoing advisory opinion processes before international courts, and one of them being the International Court of Justice that has been asked through resolution of the General Assembly of the United Nations to issue an advisory opinion, so effectively authoritative interpretation of the law or guidance, addressing what are the legal obligations, what are the obligations under international law of states in the face of the climate crisis to protect the climate system. And crucially, also, what are the legal consequences when by their action or inaction, they have caused harm to the climate system. And that question has come before the International Court of Justice because of the leadership of Pacific Island states and the movements that have of youth and of others behind them and around them to force that question. But they also not only did it in the name of Pacific Island states, but in the name of the entire world that is in the midst of this escalating crisis and that clearly has an interest in understanding and in obtaining that legal clarity from the world's highest court on what is required of states. And so that's just one of these 3 international court processes that are underway, one of which came to conclusion earlier this year with the issuance of an advisory opinion from the International Tribunal for the Law of the Sea, which had been asked to address a similar question about the obligations under the UN Convention on the Law of the Sea, UNCLOS, with respect to protection of the oceans, and issued its decision in May. And I'm happy to its opinion in that advisory opinion case. But there's also a pending proceeding before the Inter-American Court of Human Rights that was asked in this same period of time to issue an opinion about the human rights law obligations to address the climate emergency and what states must do and not do, including their obligations to regulate private actors. So we have these pending processes. We have this appeal where states themselves are turning to international courts, demanding legal clarity, demanding authoritative pronouncements of what is permissible and what isn't, of what existing law requires, because that carries weight and is valuable, and because we are in such need of a legal lever to accelerate action in the face of continued inertia and intransigence on the part of those with the strongest vested interest in this very unequal status quo.
The Law of the Seas, was that the High Seas Treaty, the former BBJN treaty?
No, that's another
Right.
very important development recently, the agreement of this finalization of this long negotiated new treaty. But I was referring to an advisory opinion that was requested by the coalition of the Commission of Small Island States, COSIS, that appealed to ITLOS, the International Tribunal for the Law of the Sea, sometimes called the World Ocean Court, to issue an advisory opinion about the requirements of the UN Convention on the Law of the Sea, which places an obligation on parties to prevent, reduce, and control marine pollution. And this opinion that was issued in May of this year very clearly found that in light of undisputed or undisputable science, that greenhouse gas emissions are a form of marine pollution, and therefore triggering an obligation of states to control greenhouse gas emissions. And that this was, historic opinion in not only because it drew in the participation of so many states. There were important arguments made both in writing and in oral hearings before the tribunal about the intersection of these two global commons, the oceans and the atmosphere, right? But that this court actually clarified that there are obligations on states to act on climate change and its drivers, greenhouse gas emissions, regardless of their source, whether they're sourced from onshore activities, that the drivers, as we know, fossil fuels being the primary one of those emissions, that states have obligations under multiple sources of law, not just the Paris Agreement or the UN Framework Convention on Climate Change, but that there are obligations rooted in ocean law, just like in longstanding customary international law and the prevention of transboundary harm, just like in international human rights law. Those are issues that are at the fore in these ongoing advisory opinion processes, clarifying that there are multiple sources of legal obligation to act on climate change and to cease action and conduct that is driving climate change. But this opinion really was the first to recognize how intertwined the fates of those global commons are and the legal implications of that, and made very clear that states must do more and act in line with science. So an objective standard for what is sufficient action to address greenhouse gas emissions that pollute the marine environment, and violate their obligations, and implicate their obligations to protect the ocean system.
I need to ask a very, very simple question.
Sure.
It might seem like a stupid question. It's that level of simple. But I'm just thinking about the Kazan Declaration that was written by the BRICS countries and published last week at the end of their 16th annual conference, which said that they reject unilateral, not policies, but like unilateral action on climate, essentially. Anything from taxes to, quote, due diligence. And that the national sovereignty of all of their countries must come first before global action. And then I'm thinking about this in relation to what you're saying about international law. This is my very simple, possibly stupid question. Does a country have to agree to international law in order for it to be imposed upon it? Can a country withdraw from international law in the same way that Trump pulled the United States out of the Paris Agreement?
So it's actually a great question, and not at all silly. I think that consent is in many ways the basis of international law. International law is made up of many different, not just agreements and treaties, not just conventional law, but also practices. It's sort of almost the equivalent of what you think about at the national level as kind of common law, but over time, custom and practice kind of ripen into and crystallize into law, customary international law. And so it's not as simple to say that as a state can simply withdraw from international law writ large. That there are, states can, under some circumstances and subject to different conditions and provisions, withdraw from individual agreements or treaties. And that withdrawal can sometimes have immediate effect, and sometimes there will be certain clauses that suggest that that the law still applies for some period of time. But lest I get down a rabbit hole of the intricacies of treaty interpretation, but I think that more fundamentally, states can't simply withdraw from customary international law, from fundamental principles and principles that are of interest to the international community as a whole, and that states have over time through their practice reinforced an understanding of and recognized through legal opinion, or opinion jurists has been recognized as a legal obligation, not just not merely custom. So there are certain ways that states can seek to carve out the application of certain laws to their own conduct. And we've seen that, here I sit in the United States. The United States does that quite often. Even when it signs on to agreements, it will issue sort of reservations or declarations or understandings that seek to carve out, to exempt it from certain provisions or to limit their application. And those, how effective those kind of carve outs are is often the subject of contestation, how they're, interpreting the scope of those, of that language, and of course, countries can't, even when they haven't ratified an agreement, if they've signed something, they can't undermine or violate the object and purpose. So there are certain fundamental levels in which they are still obliged to respect, and act in accordance with, or at least not at odds, and undermine the very purpose of certain agreements. But it is a complex situation, and of course, all law, right, is made by is made, right, in it, or at least recognized in the form of opinions and instruments. And so there is always the prospect that it could be unmade or dismantled as well, right? And perhaps this is a bit of a tangent from where you're going, but what it really makes me think about, and what's one of the things I'm actively working on and at the forefront is another aspect of the existing legal regime that is an impediment or a barrier to tackling climate change and to action on fossil fuel phase out in particular. And that is the investor state dispute settlement or investment law regime.
Yes.
And so you might have heard about these bilateral investment treaties that are sort of thousands, this network of thousands of treaties that exist. There are also multilateral agreements like the Energy Charter Treaty that some listeners may have heard of that put in place protections for foreign investors and allow foreign investors a really unparalleled, I have to say, in the scheme of international law, ability to directly sue states when the states take action or decisions that allegedly infringes on the rights of those investors or diminishes their returns, right? So it's basically put into the hands of these foreign investors a very large stick that they're able to wield against states directly, against governments when they take action that they think harms them or violates other protections that they are owed. And what we've seen is that stick has been wielded more by the fossil fuel industry than any other sector. They're one of the most prolific users of this system. And they have brought cases challenging climate action, challenging measures and policies that seek to comply with state obligations to act on climate change. So the state, on the one hand, has these duties that are being continually reinforced through national cases and at the international level to do more on climate, to act on climate. It's not just a nice to have, it's an obligation and a duty to curb the drivers of climate change and to do more to protect people and the planet. But when they do so, they're up against increasingly, and there are numerous examples of this. Just recently, weeks ago, I think Exxon became one of the latest companies to use the Energy Charter Treaty to sue the Netherlands for trying to shut down a gas field sooner, right? So when states are taking, that's just one example. I don't mean to call out that one company only. I think that there are other cases similarly when policies have been adopted to shutter coal plants sooner, or ban offshore oil and gas in Italy, or stop the Keystone Pipeline in the US, for example. Investors have made recourse to this system, investor state dispute settlement, basically these arbitration, unaccountable, largely secretive arbitral courts that aren't reviewable. There's no appellate body that sits to look out and review all of these decisions, and threaten or actually pursue claims that go into the billions of dollars, right? And so what this system has done is really turn the polluter pays principle on its head and basically allowed foreign investors to demand that they be paid. So basically paying polluters instead of making polluters pay. And it's made, but paying polluters can't be the price of climate action. But that's what this system is effectively allowing investors to insist upon, and with, really dire consequences, because it's not just those claims that are brought and then, litigated before these arbitral bodies that cost, countless, millions in attorney's fees, and then potentially results in these awards in the hundreds of millions or sometimes billions of dollars, right? But even the threat of that is a big discouragement and chilling effect, has a big, chilling effect on countries that might be contemplating taking bolder action in the environmental or public health sphere. And this isn't just a climate issue. Of course, this has arisen in the past when countries have sought to address smoking and tobacco. There were cases by Philip Morris and, in Australia and in Uruguay against those, regulations or other sort of environmental protections against mining, and other things have triggered these cases, right? But why I went there in your question, your kind of philosophical question about law and whether we can, countries can exempt themselves from it or opt out of the international legal regime. On a positive side, this system was created by countries, by states, and they can dismantle it. They can reform it. They don't have to accept it as, once created, it's indelibly there forever. And we've seen actions to start undoing this system, and as the recognition increases that there's just an incompatibility between letting, status quo incumbent investors effectively hold governments hostage, or even sort of blackmail them and say, pay us if you want to, clean up the environment or prevent further harm, that is incompatible with rapidly evolving our action and regulations and responding to the climate crisis and environmental crises. That there have been actions to exclude that kind of provision, to not allow that kind of arbitration in new agreements. And we've seen in the case of the Energy Charter Treaty, this historic decision for the EU to collectively withdraw from the Energy Charter Treaty, and individual states to say, no, basta, like enough. We're not allowing this agreement to be used to stand in the way of our ability to actually get stuff done and actually take action to combat the climate crisis and other crises. So that's a positive step, and something that we are actively trying to reinforce and expand and draw lessons from, because we can't just stop with the Energy Charter Treaty. There are many other agreements out there that still allow this type of imbalanced use of the law as a weapon, really, kind of weaponization of the law, really, to block and deter desperately needed and legally required climate action.
Can you just quickly tell me, what is the Energy Charter Treaty? I assume it's around fossil fuels, but shockingly, I don't know the details.
So the Energy Charter Treaty is a multilateral agreement that European states are many European states are members of, but not only. It's a global treaty that was really designed ostensibly to promote, and I have to look up the exact year that it was adopted. I think it was in the 80s or 90s, that was adopted to promote or protect energy industry investment, right? But I think, it ostensibly was designed to promote and secure cooperation and foster investment and policy directed at the energy sector. But of course, it has largely benefited the incumbent, energy industry, which at that time and still is dominated by the fossil fuel industry. So, certain folks will point to ways in which the Energy Charter Treaty has also been used by renewable companies to bring suit against when policy measures changed with respect to energy policy. But I think that's it's a red herring, because we know that by and large, like among the largest users of this system, not just the Energy Charter Treaty, but ISDS more generally, have been fossil fuel producers, and the figures. The size of awards or damages demands or compensation demands that they are claiming, run into the billions. So, this is just one example of an agreement that puts in place these very asymmetrical legal levers that have been wielded by the fossil fuel industry and other polluters to make it more difficult to regulate them and to take action that we need to address these emerging crises.
Yeah, I'm so glad you mentioned the ISDS, the International Investor State Dispute Settlement Courts. When I first learned about them last year, my jaw was on the floor that A, such a thing could exist, and B, that not every single person knew about it, because it is a direct theft, both of, national sovereign wealth and political autonomy by corporate powers, and particularly Western corporate powers. It is astonishing. And it reveals, I think, the complexities of the situation that we're in, and how do I put this? How intertwined this states and the laws are, because the states create their laws and they're meant to hold the state to account. But when you create the very thing that's holding you to account, where really does the power lie? And on the international stage, you can see how that gets skewed one way, how Western powers that have essentially a bigger piece of the pie internationally when it comes to decision making get to create treaties that benefit them more. And that's still being done. Every single negotiation for every single treaty on climate, it is still being done. And I say all that to preface what is going on for climate activists at the moment as well, around the world. Now, their climate activism is, I don't want to say like a new thing, but it's new to be in the press so much, I think, in the West over the past 5 to 10 years. But climate defenders have been active for decades, if not hundreds of years, around the global south, and have always been at risk of losing their lives in defending their lands, their territories, the more than human world that they share space with. In places like the United Kingdom, climate activism was no more or less dangerous than any other form of activism up until very recently. When the Atlas Network, which is a network of right-wing think tanks around the world, essentially promulgated this suggestion of policy to governments in Europe, the United Kingdom, and the United States, suggesting how to deal with these climate activists. And in some states, like in the United Kingdom, they really took those suggestions to heart and have been wielding the law against activists to some really astonishing results. We just saw that young woman, Phoebe, who threw tomato soup at a glass pane, which happened to have a painting behind it. She's just been jailed for 2 years. Really, really, really astonishing when you consider that we also know that Britain's jails are overflowing, and in some places, rapists are being let out onto the streets because there aren't enough beds. So there's really an obvious contrast between the law working to protect people and then the law working to protect power. Now, I am just very curious in this. I'm very curious in this tension of the law meant to be this third power that holds other powers to account versus being created by the state and in essence being wielded by the state. And how between that crack, a lot of harm, people are falling down and a lot of harm is being done. And how do we begin to deal with that? Sorry, that's not a very good question, but I hope the preface was good enough to allow you to just go with it where you want.
Yeah, it's a fantastic question. And it's unfortunately, it's a deeply troubling question, troubling being, an understatement, because we have seen this rapid escalation in blowback and backlash and in crackdown on, civic space and in activism, on activists and activism, and not just, activists on those who dare to confront power, right? In so many ways. The proliferation of slap suits, strategic lawsuits against public participation is just off the charts. And on top of the direct physical violence and threats and harassment that we know those who are on the front lines of climate impacts and on the drivers of climate change are facing. My mind goes so many places. There are partners we're working with and organizations that have mobilized this, tremendous transnational campaign and are are fighting in Uganda and Tanzania against the development of this massive new transboundary pipeline that is led by a consortium of companies, including Total. And they're, protesting and demanding that a rethink and a halt of this pipeline because of its devastating impacts on displacement and human rights locally, on local biodiversity, and its broader contributions to climate change, which of course compound and reinforce those. And they're facing tremendous crackdowns. I mean, the numbers of people who've been thrown into jail and arrested and harassed just for joining in peaceful protests and for raising these issues and pursuing their rights is deeply disturbing. And that, at the same time, we're seeing, slap suit against a massive, hundreds of $1 million claim by Energy Transfer Partners against Greenpeace for supporting and engaging with indigenous-led resistance to the Dakota Access Pipeline. We're seeing, different companies take pages out of the same playbook. We're seeing different slap actions designed to really silence activists working on fighting the gas developments in Western Australia. But like really disturbingly, or I don't know if it's any more disturbing, certainly not than brutalization of people who are courageously environmental and human rights defenders. But we've seen, international oil companies turn these tactics on their own shareholders. We saw earlier this year, a suit by ExxonMobil against two shareholder organizations that were seeking to bring climate-related resolutions to their own annual general meeting, right? And to discourage them from doing so, and to say that those, to use law to silence and get them to drop those things. And so the different, and I actually think it's useful to think about, it's a kind of useful analogy to think about these ISDS suits, these claims under investor-state dispute settlement, challenging climate action, or at least discouraging it, as a kind of form of slap suits against states that are maybe looking to be first movers. It's a kind of it's designed to send a warning and to chill and to chill that drive for more progressive action. So I mean, we're seeing that. Part of why we're seeing that recourse is because states and companies just can't win on the facts. I mean, because if you look at it, the facts of what's causing climate change and what its consequences are so crystal clear and cannot be contested, But so I think we're seeing this increasing almost, desperation in resorting to other tactics. And we see that also in the response, from the Swiss government to the European Court of Human Rights decision, right? In many ways, rather than seeing it as an opportunity and an invitation to intensify its climate action, because we know that all countries need to do more. No country is doing enough to address, climate change, and certainly not those in the global north that bear the greatest cumulative responsibility. But instead of seeing it as an opportunity, they turned around and attacked the institution itself, right? And started saying, and we see this not just in that case, but in so many cases, saying, this is judicial overstepping and the court shouldn't do this. And this is not what, appropriate for the European Court, or even threatening just to kind of disregard the judgment and say, well, we think we're doing enough. And so therefore, we won't comply. I mean, and so I think that I've thrown in a range of things and not just responded to the way that that the state or corporate actors are using the law, but I think it, in some instances, it's quite opportunistic, right? There's a use of the law and abuse of judicial process, or exclusive monopoly on kind of the violence of prosecution and police forces and military to punish those who would dare to confront, power and demand justice. But we're also then seeing when those institutions are successfully mobilized, when courts and the law is successfully used by advocates to rebalance power, to call into question status quo conduct, then we're seeing a kind of flip, a bait and switch, and flip on the institutions and law itself, right? And because, there's so many cases, and I know we only scratched the surface in talking, you named the Milieu de Fancy case, which I think in the Netherlands, which is another huge, historic landmark decision, the first to really say corporations have obligations to reduce their greenhouse gas emissions across the life cycle, across scopes 1, 2, and 3, direct and indirect, because of the human rights impacts. That was really important, and it's on appeal now. And we know that the decision is expected in the appeal on November 12th. I think they've already announced, unlike courts in the US where they wouldn't announce in advance the day they'll give you the opinion. In the Netherlands, that's what's anticipated. There are so many other cases where we've seen in the courtrooms a really masterful use of the courtroom for storytelling and for, of course, not as the only end. There are legitimate legal claims underpinning these cases, but it's also an important platform for telling the story around how climate is unfolding, what the impacts are on people on the planet, and what conduct is contributing to it, right? And I think we saw that in the Montana youth case, among others. We certainly saw it in the European court cases where the very cogent presentation of the science and the facts, ended up leading to decisions that really lucidly walk through. Here's what's happening. The science is there. Look at the IPCC, the Intergovernmental Panel on Climate Change's reports just reinforce time and again what we know is driving climate change, how foreseeable these consequences were for so many decades indeed, and how they're unfolding now, and what we need to do to have any chance of preventing further catastrophic harm. And when those things are laid out in that way, and the humans behind these cases are heard and seen, it has an impact on the judges, deciding these cases, and on the public watching. And I think that dimension of litigation and the use of legal systems can't be lost. It's so critically important, and it's part of what is at play right now in these international tribunal advisory opinions. The proceedings that we're looking forward to before the International Court of Justice in December, for example, where hearings will open in this proceeding on the climate advisory opinion, where we've seen this unprecedented level of participation from states around the world that is really, is really a testament to how critically important these issues are. But we are seeing states go above and beyond their capacities. States who've maybe never appeared before the ICJ or who don't have many resources to do this are supporting each other and are taking, this opportunity to highlight and to bring voices of those who are experiencing climate change to the highest level. And I think that those creative ways of testifying and bearing witness are so important and really create the social movements and fabric and sustain them, into which any legal decisions are received and have impact, right? The effect of the law and litigation is never only what happens within the courtroom or on the, on the four corners page on which the opinion is written, but really about the strength of the social movement that has led to the moment where the case arises, and that then uses and leverages what comes out of it to hold actors to account.
That's beautiful, Nikki. I think it's a lovely note to end on, that highlighting the ecosystem within which law exists and within which we are all sort of battling in the corners that we can for a better world. Thank you so much for your work that you're doing, you and everyone at the Center for International Environmental Law. My final question for you is, who would you like to platform?
I was anticipating that question, and it's such it's always hard to pick, because I think there's so many brilliant advocates, brilliant creative thinkers, and folks doing so much work. And I know you've already profiled some of the folks who I think are doing some of the greatest work, exposing corporate capture and tactics in the fossil fuel industry, the likes of Naomi Oreskes and Amy Westerveld and others. But I think, as I was just talking about, the courageous movements behind the effort to bring, the world's biggest problem to the world's highest court, if you will, the International Court of Justice movement. Both the Pacific Island students fighting climate change and World's Youth for Climate Justice have been really brilliant in the way that they have mobilized and galvanized public attention and supported states in their efforts to demand justice and to wield and leverage the law to address not only the causes of climate change, but the climate crisis. And they're now organizing in advance of these hearings. They have launched a petition that I'd be happy to send you a link to really get the public to impress upon the International Court of Justice just how vitally important this issue and how essential it is for them to clarify not just the multiple sources of obligation to act on climate, but the duty to provide a remedy when states' own failures and actions have led to harm. And they've also, among others, our organization and others have, supported something called the witness stand, where there is visual and video testimony from people who have experienced climate change around the world that has been put on a brilliant platform to really emphasize both how widespread the interest in and focus on this proceeding is, but how deep and thoroughgoing the demands for justice are. And then one other I would throw out there, which is quite a different tack, but because we had such a wide-ranging conversation, and because I think it really speaks to the type of interdisciplinary thinking that you do on this show. I think forensic architecture, I don't know if you've ever heard of them, but I think that they are really brilliant. And they are an outfit and now have launched a whole network of, the investigative commons, but take an interdisciplinary approach to addressing structural violence, state and corporate violence. And they produce and present, spatial evidence of the causes of and reconstruct kind of state violence and human rights violations in a way that is deeply insightful and moving. And they've done that with respect to the violence and unfolding atrocities in Gaza. They've done it with respect to also on the other end of the spectrum, petrochemical hazards, or looking at, climate change as a form of colonialism. And I just think that they are really sitting at the intersection of a number of different disciplines, including speaking to the law and providing evidence that can help infuse efforts for legal accountability. So would also plug them.
Excellent. Well, listen, thank you so much. And thank you so much for your time today. This was a wonderful conversation.
Thank you so much. It was great speaking with you.
If you want to learn more, I've put links to everything in the description box below. Remember to subscribe to the channel if you're new here and share the episode if you enjoyed it. To support the show, subscribe at planetcritical.com, where you can read the weekly newsletter inspired by each interview. You can also become a Planet Critical patron. All links are in the description box below. As always, my deepest thanks to that community. Planet Critical wouldn't exist without your support. Thank you everyone for listening and for coming on this journey together.